So we have talked about the basically the beginning stage of mediation when you're actually at the mediation, which is hopefully located in a neutral spot, right? Because based on the fact that there's a strong likelihood that your client has felt compelled because it is mandatory to engage in the process, we don't want to exacerbate the matter by having it at one attorney's office or another, or even in the courthouse, because then there's a perception that there's not an even playing field. So we want to make sure it's at a neutral location, and then when the mediator comes to start the mediation and get the parties together, one of the first things, and this seems again like such a fundamental matter, but a good mediator is going to immediately ask the parties what name they're comfortable using. So while you might think that everybody would say their first name, it's a lot of times people say, no, it's Mr. Jones, Ms. Smith, whatever it is. What is interesting, though, is to watch a mediation where there's some tension, where there's some hostilities that's obvious at the initial phase, and then maybe a quarter of the way through it or half the way through it, all of a sudden the claimant is saying, hey, please call me Madeline or Bob or whatever it might be. So it's interesting to see the change and notice the personality difference as the mediator works on making the clients feel more comfortable and understanding the process. So that's such a very fundamental but important step for the mediator. And then we talked about how in the initial first phase that the mediator is going to reiterate the mediation agreement that confirms that the parties will remain, that all the information disclosed remains confidential, that the mediator will not be called to testify, and as important, if not more important, is that the ground rules are set forth in that there won't be interruptions when one person is speaking. The hostility or vitriol will be hopefully at a bare minimum, if at all. Limited, no or limited profanity. Sometimes people can't help themselves, but so they're just basic ground rules that again help establish how people are going to behave and reinforce that if at some point during the mediation there's a problem, the mediator can refer back to it. And another way that is accomplished is by the mediator asking for an affirmation from each client that he or she understands what the rules are and agrees to abide by them. And that is important. It's symbolically important. It's also essentially akin to a moral contract or agreement between the client and the mediator, so that again, if at some point during the process one of the parties starts belittling the other, and this can be very common in family matters, but where one client is belittling another, the mediator can say, Mr. Jones, you may remember that we talked about this at the very beginning of this process, but we all agreed that when we're talking, or when someone else is talking, we're going to let them finish and complete whatever it is they're saying, and then we'll have an opportunity to discuss that or respond to it. So it's a way, again, as a moral contract to go back and say, well, you did agree to this, and bring it back up. These things are symbolically important, and they really help to make the process smoother. Sometimes it seems like these types of things might just be perfunctory and not really all that important, and I keep going back to the doctors and malpractice, but I'm sure that every doctor sued for operating on the wrong arm probably thinks the same thing. Well, shoot, that's so simple, why didn't I do that? Then we talked about the information exchange part of the mediation after that initial preliminary phase, where the parties will provide a summary of what their case is about. They may show a video or some photographs, whatever it may be. The client may asked to say a few things, or maybe asked by the mediator if they would like to share any additional information. And again, the summaries provided at that part of the mediation in the informational exchange is really designed to not be, it's not really going to be the same as an opening statement at a trial, because we're really looking to create a more cooperative and facilitative process rather than something that's hostile and combative. So it's important to think about how you want to proceed when you're making that initial statement. We want to keep the finger pointing from really being as overt, and maybe really stick to the facts and the strongest support that you have for your case and your arguments. Then we talk about the meat and potatoes of the mediation, which is the distributive part. And at this point, we've had the ground rules talked about. We've had the introductions. Everybody knows who everyone is. And so now we go to distributive, and this is the time that the mediator needs to make a decision between keeping the parties together. There's two options here. Option one, keep together. And option two is to caucus. Now, you can imagine that if the, first of all, if the mediation is the result of a compulsory rule or something in a statute, you know that the client may be less inclined to be as open-minded about the process and letting the process work. So really, there's not that many times, I don't think, that you'll see a situation where the parties, where you really want them to stay together. Now, sometimes mediators make the mistake of separating people too soon before they have an opportunity to, again, as we talked about with an insurance adjuster that may be at the mediation as part of the process, and seeing the attorney, the claimant's attorney, giving an opening summary and maybe showing a video or using photographs that will be used at trial, that gives people an opportunity to do their own and form their own assessments of another person's capabilities and credibility. So it's kind of a fine line between about knowing when to keep people together and when to separate them. But at this point, after all those preliminary matters are done, that's when the mediator has to make the decision. And so if it appears that there's really any hostilities or any bad blood between the two, then most likely the mediator is going to choose to caucus the parties. And caucusing is nothing more than separating the parties into their own private areas. And that's the point in time where the mediator is going to spend some time with generally the person that instituted the claim. So usually the plaintiff or the claimant, and will basically try to get a comfort level established that's significant enough to assuage any concerns that the client has about the process, maybe about the mediator. And what you'll find at the beginning part of the caucus, when the mediator comes in, you're not going to see the mediator sit down and say, well, all right, here's what you said in your opening, and start checking off things and hit the ground running as far as the meat and potatoes of the claim. What you'll find is that a good mediator is going to spend the time up front to take good care to make the client feel as comfortable as possible, and try to see if the mediator can ferret out maybe some issues, some barriers that exist, some concerns that may create barriers to moving forward with any realistic hope. And one thing that every mediator knows is that there's not a claimant on earth, and that's true whether it's someone in personal injury, medical malpractice, a patent case, trademark infringement, I don't care what the case is, obviously family law, but anything, business related or otherwise. Every mediator knows that the person that filed the suit has a story to tell and wants to tell it. And a good mediator knows that you need to provide an opportunity for the plaintiff, for the claimant, to feel comfortable telling that story. And you'll see that when that story is told, and it's different than when a client tells his attorney or her attorney a story about, whatever the situation is. But after that story has been told, the client, even though they've been told that a mediator is not a decision maker, the mediator is not a judge, the mediator is not an arbitrator, that the mediator is not anyone that's going to make any type of decision for the client, nevertheless, the client is still going to perceive a mediator as someone that's somewhat in control of the dynamic of the case, and that has some role that's beyond what a mediator really is. And so often just the ability to tell the story to someone like that will demonstrably change the personality and the way someone is feeling about the process. And once the mediator recognizes that change in personality and understands there's an opportunity now that the story's been told, that the client feels that the mediator is an active listener, and believe me, that is the number one skill that you want to see and you will see in really well-trained mediators, is that ability to actively listen and then convey back information in a coherent manner that makes the client absolutely know that the mediator was listening to what they said. So at that point, that's when the mediator is going to start talking more about the meat and potatoes of the case and begin to talk about the where the parties are going to begin in terms of an offer, in terms of a demand, and where now it's going to make talking about concessions easier, because there's a different dynamic now between the client and the mediator. So if you have an alpha domineering personality for a mediator, you're less likely to see a client that's going to feel better or more relaxed through the process. And that can work for certain clients, but you have to really be aware of the types and styles of mediators and understand what is going to work best with the type of client that you have. And in most cases, a facilitative, cooperative type of mediator is going to make the difference every day of the week and twice on Sunday. So once the mediator goes through starts the caucusing, the other side, of course, is going to be in their room, probably not doing much, but there's a lot of downtime, a lot of waiting time during the process of a good mediation. And that's one of the discussions that takes place early on when the mediator is talking about the process, so that people don't feel they're being ignored. Now, when the mediator leaves the plaintiff's office or room and goes to the other side, and the same process is going to take place. That's why you can't possibly have a meaningful mediation that resolves itself in 2, 3, 4 hours. That's impossible. The only people that believe that will happen are people that are attorney mediators, because they, like you and me and everybody else, has 5,000 things to do and they want something moving quick. And because attorneys know the process and they understand all these things and the nuances of mediation and ADR and practicing law, they don't realize that the people they're working with have no clue, and there is no way to make them comfortable in that little bit of time. So the time in a real and well-handled mediation is going to be significant. So when the mediator goes from the plaintiff's room into the defendant's room during the caucusing, the same process of, and again it depends on the you know, if the defendant is someone that's familiar with the process and that's, you know, fairly articulate and just had the experience. Depending on what level the defendant is at, the mediator may spend as much time trying to make that person feel comfortable. Oftentimes what happens though, when the mediator goes into the defendant's room, the first thing they hear is, well, listen, I appreciate that mediation is oftentimes helpful in cases where there's a legitimate dispute. However, in our case, there is nothing legitimate, there is nothing substantive or real about this dispute. It's made up, there's absolutely no truth to anything anyone has said, and so the immediate response is, you know, I really don't care what you say as a mediator, it's not going to change me. Now, to an untrained mediator, that would appear to be an almost insurmountable hurdle. To a well-trained mediator, that's almost a blessing, because when someone's taking that type of a hardline approach, that's an opportunity for a mediator to divert the attention from the defendant, maybe talk about some other things, and maybe talk about some examples of other cases where similar views were held, but then go into why that didn't turn out the way the defendant originally thought in these other cases. And so it really, when someone thinks they have their mind made up, oftentimes they're very vulnerable to persuasion from someone that's skilled in the process. And that is an opportune time for a good mediator to pull back a little bit and take a little extra time and patience and work through that hurdle, sometimes gently and sometimes not so gently, but to make the defendant understand why that thought process, while it seems principled and justifiable on its face, in further analysis, really it doesn't get the result that that person thinks it does. Because oftentimes, especially defendants believe that if they take a principled stand and they smash their fist on a table and say, we will never pay a dime on this case, blah, 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 they think that that automatically will, as they say, shut the floodgates on further claims and other actions. But the problem is that that really doesn't very often occur. If it's a very small community, it might be one result, but frankly, unless it's a really small community, and I mean really small, smaller than Southern Illinois communities, that could work, but most frequently isn't going to have that desired effect. What will happen is that, and let me step back, one of the reasons a lot of times that companies take that approach is because their attorney has said, hey, why would you pay a lying dirtbag any money at all when you know that if you let that person get away with that and you settle a case, then you're going to open those floodgates and 500 other people are going to come through and they're going to be filing suit against you. Now, why would an attorney say that? Well, certainly there is a portion of accuracy in the potential for other claims to come in, but if you think about it statistically, claims are going to come in whether a case is settled or not. Because if somebody feels aggrieved and that aggrieved feeling is not assuaged or dealt with adequately in that person's mind by the defendant, regardless of what other outcomes have been, they're still going to pursue a claim if they really feel that they've been injured in some way. So the logic behind the frame of reference that we're taking this principled stand, it begins to look like a house of cards. And it really doesn't have necessarily a solid foundation. So, but in those circumstances, a good mediator is going to take the time to really explain things to the defendant in a way that, and in using a vernacular that will resonate with that defendant. And I don't want to forget, when the attorneys are telling their client, the defendant, about taking a principled stand, what would be the reason that some attorneys might choose to suggest a strategy to a defendant that would essentially guarantee, almost 100% guarantee, that a case that could resolve itself within 6 months, by not settling it or not attempting in good faith to resolve through mediation, now we're talking about a process that could be going on for 2 to 3 years. And a process that, litigation that is going on for 2 to 3 years also translates to something very, very significant. Now, attorneys have to make money too, and there's certainly nothing wrong with the idea that a good representation can take a long time, and there's no doubt whatsoever that there are certainly cases where, for one reason or another, there's a valid rationale to not pursuing litigation, to not agreeing to any sort of ADR or mediation or anything like that, and to proceed towards litigation. But the truth is, there's rare circumstances. I mean, we know that we've already established 3% of all cases go to trial. That means 97% settle or resolve in some way. Why? I mean, if it's all about principle, I suspect a lot more cases would be going to trial on either side. Because if it is about principle, then it's not just about the defendant saying that we're not going to, be forced to resolve a bogus claim. But on the flip side, it's, well, I'm not going to settle a case when I've been aggrieved and there's no dispute about it. That company hurt me and hurt me irreparably. I mean, that argument can be made for both sides, but it doesn't really hold water. But unfortunately, you'll see in a lot of cases where attorneys, especially if they have a client that may not be that sophisticated, they use language to make this be a reality. And if this is a reality, this is going to be a very significant benefit to the attorney. Now, it kind of goes back to our discussion about the difference between zealous representation and being a zealot. You as an attorney have no place to be a zealot in the world of litigation or in ADR. That is not, if you have some viewpoint that makes you so rigid that you can never see the benefit of compromise, the benefit of creative problem-solving resolution, then you have the problem and you need to back away from the case, because that never works. And as I mentioned in some examples previously, that always hurts one person, and it's always the client, never the attorney, right? Because you hold that view, but when your client is forced to carry the baggage of that view, the outcome is, I've never seen a positive outcome from that type of situation when there's a zealot involved as an attorney. So again, this is going to be the outcome regardless of what actually happens at trial, but the outcome is going to be an inordinate amount of money spent on attorney's fees. And once you begin to practice law and you realize the amount of fees that are generated from engaging in extensive discovery that involves expert witnesses, depositions of experts, and then trial and the preparation time and the time of the trial work, I've had many clients that have had on a relatively simple case, to take a case of I don't want to say run-of-the-mill, but a standard case, one claimant on discrimination. They've easily spent upwards of between $150,000 to $200,000. Now, in one particular case that always was an example of the most egregious scenario on both sides with the attorneys, in the one case, on the defense side, The attorney had spent, 3 years working on this case, had billed over $150,000, and didn't settle the case until the weekend before the trial began. Now, the settlement amount ended up being $7,500. So the defendant spent between $150,000 and $175,000 to settle a case for $7,500. Now, what would have happened if they took the process of mediation and engaged in that process, I don't know, say immediately after the case was filed, or maybe after the initial phases of discovery? We probably would be talking about a savings. Now, the defendant may have paid a little bit more because they might have put a premium on limiting discovery. So let's say they might have paid $15,000 to settle the case, almost close to or at the time of the filing or shortly after the initial discovery. So now they waited 3 years and they settled the case for $7,500, but they paid at least $150,000 in attorney's fees. There is no way to make sense fiscally, and if you're fiscally prudent, to make that make sense. It does not work any day of the week. It just doesn't work. And then on the flip side of that case that settled for $7,500, the plaintiff's attorney had never, during the entire process of working with the client, never sat down with the client and said, Ms. Jones, your case has some problems. The judge has mentioned some of those recently when we've been getting ready for our final pretrials, and there's been motions in limine and all kinds of evidentiary issues. Whatever it may be, we have a problem. And now you're telling Ms. Jones, after 3 years of litigation, and you as a plaintiff's attorney spending money out of your pocket for obtaining records of depositions, and your time of tens of thousands of dollars, and you are going to sit down with that client and say, yeah, it's probably worth somewhere between $5,000 and $10,000. Now, it may be me, but I think there's a lot of clients that are going to have a very difficult time hearing you say that. So the problem isn't just on one side, it's on both sides. And in that particular case, neither attorney had ever given any sort of expectations to their client at the beginning of the litigation. So naturally, neither client really had a basis of information or knowledge from which to work with in a meaningful way. So that meant that the attorneys could just keep this litigation going, maybe not with any real reason, but there's definitely one reason on one side of that, and that's dollars. I can tell you the attorney that had taken the case on the plaintiff's side regretted the day that he ever signed up to take it, and to this day is just blown away. I mean, he made 5 cents on the dollar, if that, once the expenses were paid. So these are all really important aspects that the mediator is going to work on during the caucusing with the parties. And there can be anywhere from 45 minutes to an hour, sometimes 2 hours, in between the mediator going to the other side. Again, a good mediator is going to be aware of the fact that the other people may be getting anxious or antsy, maybe getting hungry. When you're in a professional organization with mediators, they're going to have already checked on people's interest in lunch and what kind of food they wanted to eat, and have those kinds of perfunctory things dealt with. Because remember, you don't want to let yourself or your client get fatigued during the middle or towards the end of these processes, because that's when your BATNA and everything else that you've worked so hard for can be tossed out the window in a heartbeat. So the mediator is going to continue the caucus, sometimes fairly close to the end, sometimes to the end. It just depends on whether the mediator recognizes a significant shift in the personalities and the way the parties are communicating. If it seems that they're, for example, if there's maybe a discrimination claim and the plaintiff, what's essential or important to the plaintiff is an apology, and perhaps that's one thing that the defendant has agreed to provide as part of a voluntary resolution. Well, that may change the whole perspective of the plaintiff, because now the plaintiff is saying, you know, if they're thinking rationally after telling their story, I said all along I wanted an apology. I know I'm not going to get, you know, a ton of money, but the one thing that was essential for me to move forward was a resolution through an apology. And so if something like that occurs, that may actually be an opportune time to bring the parties back together and to, you know, stop the caucusing. Because that downside of lengthy caucusing is that, again, you have parties that are disconnected, and it's always easier to dislike someone when you can't see them or interact with them than it is when you're face to face. And that's when you see most problems between people, between countries, between leaders. It's because there's a lack of communication and a lack of understanding. If there appears to be an opening for the mediator, and it's always a well-trained mediator, they will make sure to, at the right time, bring the parties back together and avoid the risk of things going kind of backsliding because they're separated for too long. So you can see that the caucusing process is really where everything is going to happen during a mediation, and it's where the mediator is going to truly understand your client, any hurdles, any reservations, any fears, any anger, whatever issues are there under the surface. That mediator is going to flesh those out and use those to turn around the entire, and you can see this happen, just turn around the entire environment from something that was hostile and aggressive to something that's completely different and conciliatory. So a lot rides on a good mediator, obviously. Now, during this process, of course, that's when the core aspect of negotiating is going to come into play. And so you want to try to avoid making big concessions from whatever you had originally talked about in terms of an opening offer, an opening demand, whatever it might be. You want to make the larger concessions early on, and there's a number of reasons for that, but if you start off a mediation, and we know you're starting off at a higher aspiration level, right? So your BATNA that you told your client is $100,000. You've made an opening offer or demand of $500,000. So you're $400,000 away from your BATNA. If your opponent has done the job that we've outlined here so far and been able to think about what your BATNA might be, now he's not going to know exact, or she's not going to know exactly that it's $100,000 unless he has a camera in your office. Hopefully not. But he'll probably, if he's an intentional negotiator, he's probably going to have a good idea that that's around the range that you're thinking. So if he has some awareness of that, or she has awareness of that, it's going to be difficult to negotiate if the plaintiff comes back with a response in terms of a concession that is, well, first of all, if the opening number is $500,000 with a BATNA of $100,000, the other side's response to that is probably going to be a high aspiration as well. So a case where the defendant believes the BATNA is somewhere between $100,000 and $150,000, the defendant's probably going to come back and say, well, you know, if the plaintiff's going at $500,000, we're going to make an opening offer of $10,000. Well, now both sides are back to square one. Hostilities are raised, tensions are increased, and we really are not able to limit the antagonism because we have both sides that are refusing to make much in the way of concessions. So when the plaintiff hears that the defendant's offer was $10,000, hopefully you as the plaintiff's attorney will have an idea of where their BATNA was. You're going to say, well, fine. Then my response and my concession to that is I'll reduce my demand from $500,000 to $480,000. Well, the reality is when the parties take that sort of approach, it really is difficult for the mediator and for the parties to really see that there's any good faith in the process. So you don't want to be afraid to make a concession that's substantial early on, but you always want to tie those concessions to the same thing that we talked about tying your aspirations to, which is justifying it based on evidence, based on information that you have about the case, based upon what you know about the jurors in a particular venue in Jackson County, in Williamson County, in Washington County, in Madison County, in wherever county. By you having that level of knowledge and preparation, you can make a case for justifying your concession, but don't be afraid to make a real concession, because if you open with a strong concession, it's still not going to be anywhere near what your BATNA is, and that's the main thing that you want to maintain a lock on. So that's really not a concern. But when people start out in these little drops of water in terms of the initial concessions, it only serves to create bad blood and hostilities that can basically put a death knell on the possibility of resolving a case creatively and in a way where the parties can leave in a conciliatory manner rather than an antagonistic manner. So concessions should be principled, as with aspirations. It really pays to think about what you're going to do with that, and the same holds true obviously for the other side. It's if they opened up with a $10,000 offer and then moved to $12,000, that's sending a very clear message that they're not interested in being there, and they're not really concerned about the mediator's time or the other side's time. And so those are things that the mediator is going to be really careful to explain to the parties, that you really need to put out some good faith effort at the early part of the mediation. So during the meat and potatoes part, where the mediator is going back and forth through the caucusing, going back from the plaintiff to the defendant, there will be times when the mediator identifies an impasse by one or both sides. Now, just as when a mediator that's well trained and skilled hears a client say, well, my belief is this, and therefore I'm not willing to do that, or I understand based on being at a bar a week ago from my friends that this is how this works. When a mediator hears things like that, or recognizes that there is a burgeoning impasse situation occurring, that's a time when a good mediator, is going to reframe the issues and begin turning from the positive aspects of a case to the weaknesses and negative aspects of a case. And that can take the form of bad or difficult facts, problematic case law, problems with venue and with juror attitudes. So in other words, if you're a plaintiff that's bringing a medical malpractice case, and the last 10 med mal cases that were tried in the county you're in came back with a 0 or maybe just damages only, a mediator is going to know that and is going to take that opportunity to redirect the impasse and the roadblocks and start to look at things from a slightly different perspective and change the discussion a little bit. And a good mediator is not going to start out like that generally, unless there's really a problem at the front end. But a good mediator is going to recognize when the impasse begins, and is also going to look at environmental issues. If the parties have been sequestered in a room for hours and they're tired, they need to maybe stretch their legs, have some food. The mediator is going to insist that they take a break and that they take care of any needs they have for food, drink, whatever it might be. Because it only helps the mediator to make sure that the parties are comfortable, and environmental comfort is as important a lot of times as with any other matter, as we've talked about. So impasses can be a good thing and helpful thing for the mediator to recognize when it's time to start shifting and talking about the weaknesses of the case rather than the strengths. So that distributive aspect, where we're distributing dollars and cents, we're identifying what's essential, important, and desirous on both sides, and at that point the mediator is trying to help in any way possible to create a conciliatory approach between the parties, to think outside the box and recognize maybe ways that neither side thought about that don't involve money to help increase the pie or increase the perception of an increase of the pie through other means, as we've talked about. Maybe it's an apology. Maybe it's, if it's a job issue, maybe it's a return to a particular job, or maybe it's a change in a job to something else that would be a good fit for the claimant. Whatever it might be, there are certainly always ways that you can look outside the box to think of alternatives that will make one or both sides hopefully feel that they're coming out ahead of where they otherwise would have been had they gone to trial. Always keeping in mind your BATNA. Never forgetting that. So once the distributive phase is coming to an end, towards the end of a session, and that's probably going to be closer to the end of a long day if the mediation has been handled properly, we get to the closing stage, and that's where both sides are sensing that the concessions are getting smaller. The mediator is spending less time with each side, because the mediator basically has a really good grasp of where everybody stands on either side. And so that's the time that both parties start to get a little anxious, and they start to get antsy, because they think, hey, let's get this thing wrapped up. Let's, we haven't reached our BATNA, but we're getting close. Let's just call it a day and go home. Matlock, the final episode of Matlock Series 5 is coming on. I can't miss that. So one of the things that you want to avoid is, at the closing stage, depending on the experience level of some of the attorneys, that can be a time when you can swoop in, depending on whether one side or another may be really fatigued. It could be a good time to take advantage of a situation. One of the other reasons you want to start making your bigger concessions at the front end of a mediation is that as time goes on and you're becoming more weary, you really want your concessions at that point to be smaller and smaller, if at all. Because when you're worn down, it's a time when, and skilled mediators will pounce on that. And you need to recognize that in your own situation, if a mediator feels that you still have wiggle room to get something more done, because the fact is, every mediator has an idea in mind of what needs to happen with a particular case. I mean, once they've read the mediation summaries, they've talked to the attorneys, they've heard the opening summaries, they've talked to the clients, they formulate an opinion, whether they're an attorney or not. I mean, they have 9 out of 10 times, if not more, they have some sort of preconceived idea of where this case should be. And so you've got to take care and be careful to protect your client, that you don't make bigger concessions than you otherwise would have, but for the fact that the arbitrator, or I'm sorry, mediator comes in and says, you know, we've been here for 10 hours. You've worked so hard. You guys have come so far and done so much, but I just really, I kind of see this thing as just petering out, and everybody goes home and we basically have to turn around and start all over again. And I'd hate to see that happen. And then basically try to begin motivating the client to make a bigger concession than anybody wants. And the problem with that is, I've seen this occur on many occasions where the attorney, the client, can be so worn down from this process that they actually make a concession that takes them below their BATNA. I mean, they spent all the time and all the effort to understand what their BATNA is and why it is what it is, only to end up throwing it away because they were tired, they were fatigued, and they let someone else kind of manipulate them. So that's the time towards the closing of the mediation where you want to be extra careful, step back. This is a great time for that tool that we've talked about many times of silence. Use that. Don't respond immediately to anything. You've got to stop and think. And there's never a reason that you can't ask a mediator to step out of the room, to have time to talk to your client. And more importantly, sometimes than even talking to your client, is to allow you an opportunity to regroup and look back at your notes and your files so that you can remember why you created the BATNA that you did, because you had a reason. It's not some number that you just wrote with a highlighter. It's a number that you spent a lot of time and effort to arriving at. And so if you are even thinking for a minute about changing that in some way, you truly need to step back, especially if it's after a long mediation. Make sure that there's a reason for it, and make sure that reason makes sense. And if for some reason you feel like you're being put in a place that you don't want to be put into, there is no time that you can't stop a mediation. There's no time that you can't perhaps continue it. But I will say the caveat to that is there is something to be said for the process and the effort and energy that's been expended by a lot of people to get from point A, where you started, say at 8 in the morning, to where you might be at 4 in the afternoon or 5 in the afternoon. And if you stop and if you break that, that can be difficult to regain the momentum that you had from the process. And in fact, a lot of times you never will regain it. So it would only be under an extreme situation where you would knowingly say, I think we need to stop the mediation today and resume it tomorrow or next week or something like that. It's really not a practical thing to do unless you feel that the mediator is being manipulative and maybe in a problematic way, and you just know it's not in the best interest of your client. But if you've done your due diligence in identifying a good mediator, that should not be an issue at all. So after we have the closing stage, we're pretty much where we're going to be. In mediation especially, and this is something that a good mediator is going to do. Excuse me. We have the cooperation stage or cooperative stage, where a mediator is going to look at that pie and may write the pie out or draw it out. But try to think of any ways at that end game or that end point to see if there can be any sort of value added that will actually finalize and close that deal. And sometimes it's the smallest things that make the difference, and that's why mediators sometimes will keep something that they know from early on in the process is very important to one or the other side. They may keep that in their back pocket like a good card shark. So they're going to keep that ace in the back of their pocket, and at 7 o'clock at night, where the parties are a hair away from a final agreement, they're going to keep that ace, and in order to make everyone feel a little better, that's the time they may pull that out. Often it's going to be a relatively small matter, something small, maybe totally insignificant to one of the parties, but it may be amazingly significant to the other, and so much so that they actually feel that they've been careful to protect the BATNA, they've exceeded the BATNA, and now they can go away with even more than they ever anticipated based on the way things were moving through the process. Now, after the cooperative stage, after all of the aces were put on the table, after everybody's arrived at an agreement, it's now 7:15 at night, and Matlock's over, but now Dancing with the Stars is on at 8 o'clock, and that's a problem because both clients, neither one has a TiVo. The attorneys want to see it, and they have nothing to record it on, so now it's a problem. So what are we going to do? We talked about it in negotiation. You cannot leave a mediation without memorializing what the agreement was. It doesn't have to be the final copy. It doesn't have to be written on parchment paper. It doesn't have to be written in calligraphy, but it has to be written down in an understandable way, and it has to be substantive enough that each item that was agreed upon is clearly stated, and that all parties, the attorneys and the clients, sign off on that agreement. Now, we talked about the nibble technique, right? That's the technique where you have an agreement, everybody signed it, but the defense attorney goes back to the office, and the next day calls you, or maybe a week later calls and says, look, I have some good news and I have some bad news. The good news is I was able to get home in time last week to watch Dancing with the Stars, and it was great. My expectations were exceeded from that show. However, the next day when I talked to my client, I unfortunately found out that my client did not have the authority necessary to agree to what the terms were at the end of the mediation. Now, your head is going to be on fire, and the entire process that you just went through is going to be in jeopardy. So one way that you can, or a couple ways that you can assure that a mediation agreement is locked in and airtight is, one, absolutely make sure that the people that are in the mediation, and that means whether the adjuster is there by Skype, whether the adjuster is there by FaceTime or Facebook or however they're there, that you get a confirmation from the adjuster that he or she has the authority to settle the case regardless of what the end result is. And a good mediator is going to get that confirmation also, but you have to make sure as the attorney that you know that the person there is the authority or decision maker. Because if you get that phone call, there's nothing like that when you have to go back to your client and say, well, I don't even know how to tell you this, but we have a problem. And that's not a problem that you want to share. It just isn't. So you absolutely have to memorialize it. It's a symbol. It's a moral agreement at a minimum. It could be legally binding at best. But the bottom line is, when you have all of the salient parts of the agreement memorialized and signed off on, you are going to greatly reduce and minimize any likelihood of somebody going back or reneging on that deal. Because as with negotiation, when people leave a mediation, there's going to be a lot of emotion involved with it. I mean, it's essentially been a cathartic experience for at least one of the parties, right? We're hoping that it was a cathartic experience for the plaintiff, because that usually makes him or her more likely to meaningfully engage in the process. But so through the process, the cathartic process, and all of this that happened, there's going to be a lot of emotion, a lot of letdown, a lot of strain. So then the person goes home, has dinner, maybe has some wine, and the same is true on the other side. The insurance adjuster may go back and think, the more I think about this, the more I feel like, this wasn't right. We shouldn't have agreed to this. We shouldn't have agreed to that. So that, there's always a period of time where both sides might have a bit of buyer's remorse, or better in this case of saying settler's remorse. And the way that you reduce that or eliminate it is going to be through a well-drafted document that puts it all out. And also is, of course, signed by the mediator, right? Because the mediator has worked harder than anybody, really, to get this process accomplished and get this final outcome done. And so the mediator is certainly going to take an active role. And frankly, most mediators will not let you leave. Even if you try to leave, they'll stop you physically. They will not let you leave until you acknowledge that you agree with the essential parts of the agreement. Now, that's not to say that there's some minor procedural things that were part of the agreement that might change or for whatever reason, but those are minor, and those really do not affect the substance of the settlement agreement. But remember, in order to maintain that agreement, you don't want settler's remorse to have an impact. You need to make sure everybody signs off on that mediation. And there is no better feeling than knowing that you maintained your BATNA, that you got a good result for your client. It may not be, it's certainly more than what your BATNA was. It may not be everything you thought it could be, but you saved that client money, time, but most importantly, the emotional toll that all litigation takes on all clients. It's a guarantee. There's nobody that is outside of that. So the fact that you've been able to do that should make you feel really good. The fact that you spent a lot of time and effort to assure that you obtained a very solid mediator, crucial, and that should make you feel good because you saw the value of those efforts in terms of the ability of that mediator. And when you see a mediator, I talk about this all the time in trial advocacy, but when you see Michael Phelps swim in the Olympics, or you see Serena or Venus Williams play tennis, or you see anyone that is a master of something, anything, it's amazing because they make it look so easy. And when you watch tennis and you see the Williams sisters playing, you think, that's great. But they don't make it look like it's a struggle. They don't make it look hard. They do so many things and have so many years of training that you don't see. You see a finished product that's beautiful. But the same thing is true of a good mediator. A good mediator is going to be down to earth, is not going to be pretentious, arrogant, is not going to be patronizing to anyone, will be firm but fair. But most importantly, a good mediator is going to make it look like it's not a whole lot different than spending time somewhere with some people that you know in a comfortable environment. The clients will never really know all that went into that process of shifting gears from hate, hostility, antagonism to conciliatory, facilitative, cooperative process that may very well take an otherwise destroyed relationship, and especially in family matters and business matters where people need to continue working together, and have allowed those relationships to continue on into the future in a completely different way because of the skill of the mediator. And it's a skill that takes years to really obtain and so much practice. You could do all the simulations you want in terms of being a mediator, being one of the participants in a mediation, but the bottom line is one thing about all aspects of alternative dispute resolution is that you can never or should never stop learning and honing and refining your skills. We talked about in negotiations that you've